talking about estate planning. I'm going to go over common issues in the estate planning. It's really educational today. Common pitfalls, our process, how we work with clients. Okay, so someone has trouble with the audio, but you can hear and see me. So that's the main thing. Okay, good. So you can listen and hear me. And can you see the screen as well? I do have a screen on as well. It says the truth about estate planning. Perfect. Excellent. Okay, so good. So we are going to get started. Today you're going to be hearing from me. I've got about 20, gosh, now it's like 22, 23 years of experience in the field of estate planning, about 15 years of business planning. So that's what our firm does. That's our core competencies. I'd say about 70% of our clients are estate planning clients and about 30% are business planning. We don't do personal injury. We don't do litigation. We don't do other areas of law. This is what we do. One of the handouts that you had received is, looks like this. It's called Selecting and Working with an Estate Planning Attorney. If I was in the market looking for an attorney, interviewing them, these are the questions I would be asking them, knowing what I know. Everyone asks about price. I promise we'll talk about price, okay? But there's about 14 other questions you should be asking your attorney. And so this is a good sheet. If you don't learn anything else today, you'll get our why we're asking the questions. At least you'll have our answers, and then you can make your own decision with regard to it. A lot of misconceptions when it comes to estate planning. And if you do have questions, feel free to type them in the chat. Towards the end, I will open up the mics, and you can we have a small group today. You can ask me questions at the end if you want. And also I'll address any questions. I see you guys have, you all have things in the chat. With that being said, let's get started. I'm a very blunt attorney, so most estate plans don't work. I mean, how would you know if your plan worked or not? Maybe when would you know might be a better question. And maybe it's after you're gone, right? So you wouldn't know. But let's break it down. And my goal today is to have you feel comfortable, at least on the issues. And so I think the starting point is, I'm a visual learner, and I tell my clients, look, on the estate planning side, visualize a time after you've passed away, okay? And you're looking down from your cloud from above. All my clients look down, they don't look up, right? Beats the alternative. If money's going where you thought it would be going, and people doing what you thought they'd be doing, then that's generally a plan that works. Money not going where you thought it'd be going, taxes, wrong people, wrong organizations, or there's a bunch of administration or assets getting frozen, probably a plan that didn't get work, right? And so you probably have an idea of that snapshot, but we need to make that snapshot a little bit clearer today, my goal. All right, so what are some typical planning traps? So the typical planning traps are as follows. Let me just say this one thing. Hold on, I apologize. Okay. All right, so the typical planning traps are as follows. People are focusing on documents. What document do I need? A will, a trust, a power of attorney, a medical directive. Yeah, those are tools, okay, when it comes to the estate planning field. But I think that's short-sighted when you actually see the whole process through, and you see what happens throughout the administration process when there's a disability or death. And so let me kind of give you an analogy first and then bring it home for you. So I don't know if any of you have seen the show, The Fixer Uppers with Chip and Joanna. They're a couple that goes and renovates houses. If you haven't seen the show, they're just a couple that goes to houses. They renovate houses. And Joanna is the one that sits down with the clients and asks them about their visions and their goals and how they want the kitchen to look and feel, the bathrooms, right? And Chip is the carpenter who comes in and has the tools and makes it happen, okay? And so my point is, my analogy from that to an estate planning side of things is, have you ever seen anyone ask what tools Chip's using, right, to fix the countertops or renovate the kitchen, right? No, we want it to look and feel like this. This is the end result that we want. What tools that were used is an analogy towards the tools of the estate planning attorney's toolbox, right? The trust is a tool. The will is a tool. The medical directive is a tool. Which tool is right for you depends on what your goals are, what you're looking for from your family. So there's no one size fits all. It just depends on what your specific situation looks like. And to be very blunt, right, the mission in our firm is very clear. Okay, I'm the business owner. I'm the lead attorney here. And our mission is very clear, right? When we get that call, when someone has died, that death notification, we want to be able to tell the clients, everything's in good order. Just be with the family when you're ready to come in and talk about this. We'll lay out exactly what needs to be done, who's doing what, and we have an orderly process for that. Okay. It's not, I think everything's in good order. I don't know. I'm not sure what's happening. So we did a document for you a couple of years ago. I'm not sure if that works. So the document is not going to drive the planning. Okay. The document is a tool, but it's who you're working with and the process to get you through that difficult time is what makes the difference. Okay. Because no one understands the documents, lay people typically, they don't understand what. I ask people if they ask me to review their trust. I said, can you tell me what it says? They have no clue, usually. So that's the important point is we want the end result, right? Is let's make sure that we have a calm, smooth transition, peace of mind during a very difficult time, right? I mean, at least make life a little bit easier for the family during a difficult time. Another trap that people fall into are tax traps. I don't need to do any planning because I don't have a taxable estate. And taxable estate means you have an estate large enough where the IRS says, hey, not only do you pay income taxes on your social security number all your life, you've made enough money where we're going to charge you an excise tax on top of that of 40%. And those exemptions have gone up significantly over the years. They're going to come back down a little bit, but still not going to apply to people. Right now, you have to have more than $12 million to have a taxable estate. Good for you if you have that, right? And that doesn't apply to a lot of people. It's going to come back down to $5 million in 2026. That may still not apply to you. Maybe it does, okay? And so it just depends on where you are in life, but it's not just the tax issue, okay? Not the estate tax issue, but now they pass different laws, the IRS, because now they're trying to find other places to get the money, right? And now it's retirement plans. And usually if you have, most of my clients have IRAs, 401ks, TSPs, 403bs, whatever retirement plan you want to look at, that's estate planning. When someone dies, there's a beneficiary designation. And guess what? There's tax impact on how you do the beneficiary designation on that. And there's new laws out there called the Secure Act with new proposed regs that are going to impact your beneficiaries' estate income taxes. So, there is just a different way to look at it, okay? And it's not only the taxes, there's a lot of other issues that we'll get into. And then the transfer trap people think is, I just want to avoid probate. And whatever that is, they don't know what probate is, right? Probate is basically a court supervised audit of your affairs after you die. I think it's completely avoidable if you want to. It's not the primary reason to do the planning, but I don't have any of my clients go through it unless they absolutely want to do it, unless there's some issue that they want a court or a judge to arbiter, right? Why would you drive your family have to report every penny of income and account for it and pay people and professionals to do that when you can have all that done privately? There's still going to be work to be done when you're not on the court schedule, but you don't have to show your work to them, okay? You got to show your work somewhere and IRS and the like, but you don't have to go to another level with regard to that. Okay, so those are some of the typical traps that people want. I want to avoid probate, I want to save taxes, I just want to document, fine. But you need to understand all the issues before you go that path, and then you make your informed decision. So that's today's goal, is to get you an idea of what's really missing, is knowing all your options and getting with a firm or attorney that will counsel you on your options specific to your situation and give you some good concrete recommendations. A lot of times people don't know their options and their snapshot looks kind of fuzzy, right? The goal today is to sharpen that picture. And a good way to sharpen that picture is to define estate planning, okay? One of the first questions I would ask my estate planning attorney is, how do you define estate planning, right? And so this is how I define it. It's not just my definition of estate planning. It's not in Black's Law Dictionary. It's not in Webster's. I'm an instructor for the National Network of Estate Planning Attorneys. This is our definition. I like it because it covers all the issues. As long as their definition covers the issues and makes you aware of them, that's what's important. So I'm someone core fundamentals, right? So here are the definitions. Here's where we start from. So the definition of estate planning goes like this. I want to control my property while I'm alive and well, right? Never had a client have a problem with that one. Total control while healthy, alive and well. Number two is a plan for me and my loved ones if I become disabled. Mental disability, right? You have a stroke, accident, something where you can't manage the checkbook. What happens then, right? And so that's part of estate planning is disability planning. A lot of people miss that one, okay? Control while healthy, plan for disability. Then I want to give what I have to whom I want, when I want, in the way that I want, okay? And I find a lot of people don't know their different options, okay? And we'll go through your options on the way you can leave your assets to your loved ones. And we try to set the bar high, all while assuring my wisdom is transferred along with the rest of my wealth. So if there's a way we can capture some values and life lessons while we're at it, this is a good place to do it, okay? Everyone has a different view of that. My job is to be the counselor, show you the options, and you decide whether you want to take them or not. This definition of estate planning, the way we approach it at our firm, okay, every firm does it differently. I like our approach, obviously, we use that approach, is we use this planning pyramid as our counseling philosophy with our clients, where we start with the most important issues towards the base of this pyramid, and we work our way up, right? So every client that walks through our door, we first want to get to know their specific situation, okay? Are you married, divorced, widowed? Are you single? Are you as a family? Do you have kids? Are the kids minors or are they adult children? Are there any health issues with the kids that we need to worry about? How are the kids' marriages? Strong, shaky, right? How do they get along with one another? Age doesn't necessarily equal experience when it comes to finances and like, how are they with money, right? And so that is the first part of the process, is just getting to know your situation. So then we can give you some good recommendations to preserve wealth, expand wealth, and save taxes. If I give you a tax strategy without even knowing who you are, that's not giving you any good advice. And if I give you a plan and quote you a fee without knowing your situation, I would be concerned if I'm you that this person is just giving me their word processing rental fee, and there's just going to be some form that comes out that not really related to what my situation is, right? So the idea is you teach us about the family, we'll teach you about the law, and together we'll make the plan work together, okay? That's the way we work with our clients. 4 keys to an estate plan. I get asked to review people's plans all the time. And if I check these things off, you've got a good plan, okay? Did this person, number one, get good personalized counseling as opposed to just a word process document, right? You can go to LegalZoom if you want a word process document, and that may be what you need, okay? It depends on where you're at in life. And yes, I spelled counseling with 2 L's, where hopefully my law license in Virginia, I don't know if I put it up in this area, but there's a counselor at law with the 2 L's. So maybe there's something that we're bringing to the table that will help your family, right, to bring it through. I'm hoping my experience and my education has helped on that with regard to that. Number 2, proper asset ownership is really critical. There's only 3 ways you can own your assets. 1, in your individual name. 2, jointly. A couple different ways you can hold things jointly, right? And number 3, contract. The third one gets people. Contracts are things like IRAs, 401ks, TSPs, transfer on death accounts, POD accounts, annuities. A trust is a contract. And so people get confused. If you have stock options and business interests, agreements, shareholders agreements, those are all contracts, and just need to know your way around them with the knowledge of where you want to get to on that, okay? And most people don't understand how that works, because you're not in this field, you're not doing this every day. And then number 3, a formal review process. Let's take a look at this every so often, because guess what? The laws change. They're going to be changing again next year, okay? I know they're changing in 26 because the tax laws are all going to sunset if Congress can't get their act together and figure something out. And then your life changes, right? Families change, the dynamics, the finances, they seem to be volatile these days as well. So we don't live in a vacuum, right? And so we need to have a plan that's adaptable for changing times and circumstances. And then number 4, let's have a controlled transfer process, right? You probably wouldn't be listening to me today if you weren't looking for something like that, right? And so I'm going to be very blunt again. What if you were to die today? Let's say you die today. How prepared is your family if something happens to you today? It's about as blunt as I can be, right? You die today. Would they have any idea what to do? how to do it, or how to pay for it, right? No document's going to do that for you, all right? And so that's the key there. And so that's, to me, is a whole, you look at the whole picture and what do we want to try to do? What are we trying to get at? There's 5 major ways to plan out there, okay? You can do no documents. You can do a will and a POA. I'm sorry, the estate planning world has a lot of acronyms. Power of attorney stands for, POA stands for power of attorney. There's a couple different flavors of powers of attorney. There's what's called a financial power of attorney, which designates an agent to make decisions for you. And there's even 2 subcategories of those financial powers of attorneys. There's what's called a durable general power of attorney, which is effective immediately when you sign it. And there's one that's effective only when you are determined to be disabled, okay? That's called a limited and miscellaneous. Some attorneys will call it a springing power of attorney. Do you see the difference? One, someone can sell your house right away. One, you have to be determined to be disabled first. Now, maybe you have you have a high level of trust with your agent, which you should, and that's not an issue. Maybe we do that, but you need to be counseled on it before you go that direction with regard to that, okay? The other flavor of power of attorney is a healthcare power of attorney, sometimes referred to as an advanced medical directive. That's a legal document designating a healthcare agent to make decisions for you when you can't communicate them to the doctor. So that one only kicks in when the doctors say, I don't understand what this person is saying. They're not communicating. Let's go to their healthcare agent, okay? So those are the powers of attorneys that are out there, and they're important documents. Which one's right for you depends on what the situation is, the family dynamics and the like, right? A will with a testamentary trust, stay with me, a last will and testament. Testamentary trust is one that's created after death, okay? And it has court oversight. I don't know why anyone would do that, okay? So I don't want court oversight over my trust after death. So, but it's out there. And you have the powers of attorneys. And then you can do a simple trust. I've seen these a lot. These have very little counseling. They're basically word process documents, and they've just switched out the names and the like. Okay, I'm not a big fan of those. And I just call the way we do it, I just call it the modern approach, right? The documents are part of the deal. It's something happens, we got the plan in place for it, right? So those are your options. I think in here is all just bare bones planning, bare minimum, which may be where you're at. No documents is no planning, and I'm obviously going to be more to the right on that side, is more a comprehensive side. Here's your challenges in the estate planning world, right? Mental disability, biggest challenge I think out there today. Why? We're going to get into more detail. Well, why do you think that is, right? Because to be blunt again, when you're dead, right, we don't have to deal with you, right? So I'm sorry to be blunt with that, but mental disability, you're here, right? We have to figure out where you're going to live, what kind of care you're going to get, where the money's coming from for that care, right? And make sure that it's all according to your goals, right? And so a lot of people haven't thought through that issue. It's a big shock when they realize that to have nursing home or assisted living, most people don't want to go there. They want to live at home, right? Most of my clients do. It costs a lot of money, okay? We're talking $6,000 to $7,000 a month to $20,000 to $30,000 a month, depending on the level of care, a month, okay? And it blows through retirements. It hit my family. That's one of the reasons why I got into this. My dad had dementia, and he loved us, but he never really planned for this. This is why I got into the field. So that's mental disability. I'll get more into it a little bit later. Asset transfer on death, that's a challenge. Rather than have things go through probate, go through getting frozen at financial institutions, I want to smooth transfer those assets to the next person in line without going through a lot of red tape, right? Taxation, obviously minimize taxes to the greatest extent possible, and then meet your personal planning goals, right? And I'll show you what the personal planning goals that we find often that our clients like. And so we'll get into those. All right, so our approach to it, just so that you know, our approach is a 3-step approach, a 3-step strategy. We want to empower, it's all about empowering you, right? Empowering your family, empowering the design, giving you the control, but we'll help you, right, with the design, right? We know what we're doing on this side, and we'll narrow the options. So the first part is developing your plan with counseling-oriented planning partners, right? Counseling being the key phrase, where they'll sit down, talk to you, and make sure they give you concrete recommendations after analyzing the situation. And if you have a financial advisor, that's why I say partners. Hey, that's going to be helpful to us. We'll be working as a team, a CPA, no problem. We'll work out. They're a little bit busy right now, with the extended deadlines, but we work with a lot of them. Number two, then we want to maintain the plan, empower your legacy, commit yourself and your family to a continuing maintenance and education program. So let's just keep this up to date with changes that are happening, not make it onerous. And I'll show you our option for that. And it's optional, our maintenance plan. And so we try to make it affordable. We'll go through that. And so then when something happens, we want to empower that inheritance for that next generation. We want to secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So we're looking all the way at the end, okay? We're not short-sighted where I'm saying, here's some documents, I'm gonna go find my next client, right? We're there, we're gonna do it the right way, we'll do the follow-up, we're gonna make sure everything's titled right, we're gonna stay with you, and when something happens, we're gonna be in the best possible position to help you. Makes a lot of sense to me, but you're gonna find most firms don't operate that way because it's just a lot of work, okay? And I have a big team, it increases my overhead. It's the right thing to do, and it makes things go smoother in the long run, okay? All right, so then the next thing is the typical planning traps. Only goal is to avoid probate. So let me teach you about probate. I'll teach you how to avoid probate without any legal documents from me at all, or anybody, okay? So if that's your only goal, you need to learn some of the lessons. So number one, I have a lot of engineer clients, so they like formulas. So the formula is this. If you own anything at your individual name at death, so look at any of your accounts or anything that own in your individual name equals a will, and will equals probate, okay? A lot of people came to me and say, oh, I got a will, I don't have to go through probate. No, that guarantees the probate process if things are that way, okay? So that's where we start from. So how do I avoid that? Okay, you can title things differently. This is all about titling your assets, okay? Part of what I'm doing is just making sure everything is titled so it's as best possible titling according to your goals, right? So one thing you can do is title your accounts as joint tenancy with right of survivorship. I'm not saying you do this, okay? I'm not recommending you do this. In fact, maybe it doesn't make a lot of sense to do this, okay? But if we're in a married couple situation and it's joint tenants with right of survivorship, that means when one joint tenant dies, okay, the people give the death certificate to the bank or wherever, the asset will go outright to the survivor by operation of law, okay? No probate. Great. So let's say a married couple situation and that happens, okay? First death occurs, oh, that was easy. Okay, what happens on the second death, right? And so, oh, we're gonna leave the surviving spouse, right, with all the issues to figure out how am I gonna title this now that I'm in the grieving process to figure all this out. Why don't we just get all that stuff set up when both are there and figure it out the right way up front? And if you're thinking, oh, I'll just put the kids on there, you're taking all their liabilities as well. They get sued, they get divorced, that's fair game, okay? And they're full owners of that as well. Maybe what you want, and there's income tax issues. So not a great way to do the planning. Transfer on death accounts, okay? Those are the bank's contracts or the financial institution's contracts. I'm not a big fan of their fine print on those, and it'll say it'll go to those people. Now, is that all you want to do with that money? Depends on the amount of the money that's in there. If it's a minimal amount, maybe. But if there's something to protect, you have options. I'll show you your options, okay? And then planning with the box deals with things like your IRA, right? That box is those beneficiary designations. Big impact on those, on which ones you select as far as the income taxes or life insurance proceeds, right? So rather than guess, why don't you get with someone who knows the issues, knows your family, and say, no, this is the best recommendation given what you're trying to do. There's probably a lot of money at stake. A lot of my clients have a good amount of money in retirement plans, okay? Here's what I mean by personal planning goals that maybe you're missing out by just avoiding probate. You're being short-sighted. So one I've already talked about, right? I already talked about basically is disability planning. So what if you did have that disability, that big illness towards the end of your life, right? Stroke, Alzheimer's, and the like. Do you have an opinion if you'd rather be taken care of at home or in a nursing home, or you don't care, right? And so if you have an opinion, where in your legal documents does it say what your opinion is? Some people say, oh, I did that. I got a medical directive. Oh, really? Let me see your medical directive. The medical directive is a state statute. It's a statutory form, okay? And the doctors will accept it. It says, you're my agent. You're my healthcare agent. You can check me into a hospital. You can check me into a nursing home. You can keep me at home and bring home care in. You decide, right? If it's that important to you, why don't you put what your instructions are in there? And if it ain't that important to you, you're not doing anybody any favors. Okay. That is one of the biggest burdens you can put on a family member. That was what our family dealt with my dad. All right. And he loved us, but he didn't think through the issue. And we weren't going to put him into a nursing home. But it cost my mom not only a lot of money, but a lot of emotional burden, okay, of dealing with that, where he was getting round the clock care and it blew through his retirement. Very real situation. Okay. So the idea is, would you rather leave instructions for your own care? And so that's what the attorney's job is we have checklists to kind of go through this to raise that issue, because you can't predict every situation, right? How aggressive you want treatment or not in different scenarios. And so we try to raise that discussion with your healthcare agents through checklists and document it, okay? And then on the financial side, that's a big deal, losing control over managing your money, right? But if you're sending checks to the wrong people, that can really hurt. You worked really hard to build that wealth, and now it's just now these people, I call them the predators of the world, are circling, and that can be taken out of your estate very quickly. And so it's a controlled way of not having, just any two doctors anywhere in the world decide if you're disabled. It's a personalized definition of disability. So the 3 questions that we go through with our clients when we're dealing with financial disability, right, is when am I determined to be disabled as I define it? And who do I trust managing my money if I am in that situation? And what can they use the money for? When, who, what? And we have a private definition. Is it any doctor? Is it your doctor? Is it also a family member? Could it be a spouse or a beneficiary or a child or a friend that make the decision in combination, right? Because your family knows you better than anybody else or your friends. And it's not a cold clinical decision that's out there. And then a private transfer is, okay, I've got things all centralized in this nice little bow. And usually we will use a trust, and I'll talk to you about a trust in a later slide. And then pass that on to the next person. And I've laid out what I want to happen. I want to stay at home. You can go ahead and renovate the house, lower the countertops, make the doors wheelchair accessible, those types of things for that. So that's what I mean by when, who, what. If you are, and this is not a course on Medicaid. So this Medicaid is catastrophic illness planning, is where you got in a situation where you need elevated care around the clock and may need to go into a nursing home, and the bills are just the money is going right out of the estate, and you're going to end up with nothing. Okay. There is ways through the use of trust to protect some of that from that. And it's, lack of a better word, Medicaid planning or planning proactively on that side of things is a way that there is a way where the government will pick up some of the bill, if planned properly in the specific situation. Okay. That's enough on that one. Okay. So that's one, is catastrophic illness protection, big issue in the estate planning world. The second is remarriage protection. I don't spend, too much time on this. It's not about trust between the married couple, but let's say I'll introduce you to my favorite, my favorite cast of characters, Bill and Mary Sample, right? And they have 2 kids, and they have the I love you wills. I love you wills are very common. I review those all the time. It says when Bill dies, everything goes to Mary. When Mary dies, everything goes to the kids. And if Mary were to predecease Bill, everything goes to Bill and then goes down to the kids. Very common, right? So I always knock off the guys first. You guys can do whatever you want in your plans. It's just statistics, it seems like, right? So Bill dies, leaves everything to Mary. And let's say Mary meets Bo the tennis pro, right? And they fall in love and they get remarried. And let's say Mary's will says everything goes down to my kids, but Mary predeceases Bo. Even though Mary's will says everything goes down to her kids, does Bo have a legal right to those assets just by virtue of being a spouse? Absolutely. You can say, I don't care what that will says. I'm a spouse, right? I'm taking my statutory share. And every state has different rules on it. It seems like they're moving towards a newer type of almost like a family law type of paradigm, where it's a number of years. Once you get to about 7 or 8 years, it's like 50%, you're good. Up to that point, they'll be like staggered 10, 20, 30, 40. So it depends on the length of marriage on that. So, and there's another thing on that remarriage protection. Let's say that, when we talked about things are titled jointly. So let's say that Bo and Mary, the new spouse and Mary, titled joint accounts. Well, joint accounts are not going to go through your will or your trust. It's just going to go to the surviving joint owner, right? So those assets are going to go to Bo, anything that's titled Bo. And for those who are familiar with IRAs, Who's typically the beneficiary of an IRA in a married couple situation, right? The advisor is just writing down, oh, spouse. So it's a contract, okay? And it's going to go to that spouse. It's not going to go to the kids, right? So if you're taking notes, title trumps the legal documents. The way things are titled will trump the way. And so if there's a way that Bill could leave all of his assets to Mary, she could do whatever she wants with it. But when she passed away, it had to go down to the kids. Is that something that's worth spending some time talking about? I don't know. My job is to raise that issue and we talk about it. If it is, check it off. We got it covered, right? That's the attorney's role, is to make sure we've got everything looked at, right? And we've looked thoroughly at the beneficiary designation, how things are titled, your goals, what's going on. Creditor protection. So creditor protection, this is probably the bigger one in our firm. There's a lot of misconceptions about creditor protection. So the way I explain creditor protection is I use what's called, I call as my school bus story. And so there's two assumptions in the school bus story. Let's use myself. I'm dead in the story, unfortunately, right? And there's no creditor protection for me while I'm alive. Okay, so let's say I've died, and let's say my spouse is all distraught and is driving down the road. It's kind of like today. It's in Northern Virginia. It's kind of like a rainy day. It's a little slick out there. She runs a red light. Bam! Hits a school bus full of kids. Let's say horrible facts. Let's say one of the kids dies. She hates herself. The world's against her, right? And so there's going to be some creditors after her, right? This is catastrophic creditors, all right? And so there's a couple different ways, and it's going to wipe out, whatever they have, but there's a couple different ways I could have left my ass more than any insurance that they have, right? The insurance is not going to cover that, right? So a couple different ways I could have left my assets to my loved ones. Here's my little school bus picture. And so here's a couple different ways we can leave them. So number one is I could have done a simple will. I could say when I die, everything goes outright to my spouse. It could be my kids, anyone we want to do. I'm just using spouse. Outright the spouse. Spouse hits the school bus. There's creditors. All that money that I left her gone. Okay. Let's say I title everything jointly with right of survivorship or transfer on death designation, right? We avoided probate, but all those assets are outright in her name, gone. Okay. Let me thank you very much. We'll take that money. Third is by contract. Let's say I have a life insurance policy. It's not worth a lot while I'm alive, but it turns into $1 million when I die. Puts it into her account. She hits a school bus, gone. 4 is those simple trusts that I've seen that have very little counseling behind them. Says outright to the spouse or beneficiaries, gone. All right, so the last way we could have done it, let's say I did my planning again. Let's say I pulled myself out of the grave, did my planning again, right? Let's say I did it this way. Let's say that I could have left my assets to my loved one, my spouse, kids, whoever. They could use it for whatever they want, but if they hit the school bus, protected from their later creditors. So let me say that one again. They can use it for what they want, protected from their later creditors. So I want to make sure you're connecting the dots. Remember that point of the definition of estate planning? I want to give what I have to whom I want, when I want, in the way that I want. A lot of people don't know you can do this, okay? How many of you would like to leave your assets to your loved ones that way, protected from their later creditors? And guess what? If they need to go on, if they have a catastrophic illness of their own, right, and have a long-term care issue, Medicaid is a creditor, protected for them. It's like long-term care planning for them, okay? How many of you ever been asked that question before? What's the value there on that? I don't know if that makes a lot to you or not, but someone better talk to you about that and go over it with you. And if you say, nope, we don't need it, then at least we've checked that box off on that. So I'll give you a quick primer on trust and how that works. And so most of our clients have revocable trusts. And think of a revocable trust as like a box, an open box. You can get in and out of it when I create, it's just a contract. And we stack the deck in your favor. But basically, the idea with it is you can get in and out of a revocable trust, your creditors can't. So a lot of people think, hey, I've got this trust, I'm protected from credit. No, I'm not saying that, okay? Revocable trust means you can change it, do it, amend it, whatever you want to do. But when you die, then you can put the lid over and say, this is my hard-earned wealth for my beneficiaries. They can use it for whatever they want, but my money's not to be used for their creditors. My money's not to be used for their ex-spouses. My money's not to be used for Medicaid to spend down. With their money, do whatever you want, right? So you can give them very liberal access depending on their investment skills. That's more of a counseling issue. But you could say, for other parties, you can give them the key, but for the outside world, no. Okay. So that's just a basic primer on that. Divorce protection, I don't spend too much time on that. It's just how would you like to assure that the assets that you leave to your beneficiaries actually stay with them, right? And so it doesn't go with the new outlaws that are out there. And then the bloodline protection planning, people call that. And then the next is the baby, what I call the values promotion, the babysitter story. And so I got started late in life with kids. I've got a 6-year-old daughter. And so if any of you have kids or even been a kid and had a babysitter, right, when we were hiring the first babysitter, one spouse is typically saying, okay, she's going to want to stay up late, leaving all these instructions. She's going to want to stay up late. She's not going to want to brush her teeth. If you read a story, read every page. Because if you skip a page, she knows. I don't know how she knows, right? We're going to be here. The neighbor's information is there. This is right. A lot of instructions just for one evening. And so my point is simple. Would you agree that we leave more instructions for our loved ones when we're going away for just one evening for a dinner and a show than we even think about leaving when we're going away for a lifetime, right? And so it's not something where I'll just give you a blank piece of paper and say, hey, give me your values. There's places where we can identify, record, and memorialize that legacy. All right. So again, this counseling is basically, my analogy to that is like going to the eye doctor. I found out what this machine is. It's called a phoropter. But remember, how they say, which one do you like better than one or two? I can never figure out it, but that's the point of the counseling is I'll go through and I'll narrow down which one do you like better, one or two. I'm not going to give you like 20 things to choose from. Once I know your goals, I'll say, okay, I can narrow it down to one or two for you, and we co-create the plan. So that's counseling. I'll give you a little flavor of that. Now the maintenance plan. So I used to spend a lot of time on our maintenance plan. So, hey, we've got it set up. If you die the next day, being blunt again, then okay, we're good, right? But I'm hoping you're going to be with us for a while, right? And so things are going to change. And how do we do that? How do we address those things? Changes in your life, changes in the law, even the changes in our techniques. I've been doing this for 22 years. Our trusts look a lot different, and our techniques look a lot different from 22 years ago, right? Because I do different training, different techniques that are being brought out there, different laws. You're getting 22 years ago. If you just did it 22 years ago, you're getting that attorney's best shot at that point in time, right? So in order to address that, and most people just, they don't want to pay the attorney hourly. I get it, right? And people don't think that it's worth the time. And even if you did it, they think it's that you didn't even do it, right? So I don't like hourly billing. We don't do that approach for our estate planning clients. For our business planning clients, if we had to do contract reviews and there's an attorney on the other side, there's no way I can get around that. But for estate planning, typically, it's just going to be a flat fee. So our maintenance plan, I'll tell you one of our fees. So it's an optional fee. It's $975 to $975. Well, it's $1,500 to enroll in the maintenance plan, and then after that, there's $975 a year. What do you get for that? And it's optional. So the enrollment costs a little bit more because we're doing some more work to get you set up that you don't even know that we're doing in the background. Okay. And I'll show you what we're doing. So the first part of the maintenance plan is we're not going to nickel and dime for phone calls, emails, faxes. You got a question, call us, and we're going to be addressing that. Now, we schedule phone appointments, so my phone's not ringing off the hook, and I have different phone blocks during the week so I can be ready for the call and ready to go. Obviously, if you're in an emergency, you're going to get bumped up the queue. And what do you think is an emergency in our firm, right? Everything stops when we get the call for death. That's the most important client, right? Our mission here is when we get that call, right, from the death notice, we want to say, everything's in good order. Just be with the family. Like I told you before, we have a process. But I don't want them to say, trying to find us. I mean, we want to be there for you. That's what it comes down to. Okay. That's the mission that everyone on our firm, our team of 12 rallies behind. Copies, word processing amendments, someone moves, someone gets married. I'm not going to nickel and dime you. That's part of the deal, the $975 a year. Okay. Annual funding double check and ongoing funding support. I'm sorry for the wording, and it's not my wording. It's just the way that the estate planning world, but you need to understand what funding means. And so I'm going to show you what we do and what the value of it is. So what I mean by annual funding double check and ongoing funding support. So first, We got to verify everything has been titled that we do in step one and getting everything into your trust and planning, which I'll talk about. But then everyone's going to get an asset review report. This is an important tool, okay? This is a down and dirty, basically, inventory of your estate so that you get hit by the bus. I'm not playing Sherlock Holmes to go find everything. I know where everything is at. I know it's titled properly. If I've got a check mark by it, I got a piece of paper in the file where it's verified. We've done 52 administrations. We know what we're doing. We know what we need, right? I've already been to the end. So I'm making sure the file is in good order. So every year we just upload this to your portal, or you pick it up and you get the new values you give us the new values of the account. So I make sure that you're not going to have a tax issue or a Medicaid issue. And then if you sold something, cross it out. If you bought something new, add it to the list here. And so that's one way that we're checking. And every year we're doing that. That's our annual funding, means titling of the assets. Okay, it's kind of a misnomer, but funding we're going to get into is putting the assets inside of that box, that trust, titling. And it's work. Okay, it's not just documents. The documents are the almost the easy part with regard to that, right? The funding is a tedious, time-consuming part. We have a funding coordinator. Okay, we have a junior funding coordinator. So it's important enough to me that we have two people to do this, because it's so much work. You need a PhD in form reading to figure out all the different types of assets our clients has, what you get to fill in to make sure it matches their goals. And the clients don't know how to do that. I'm sorry. It's just a lot of stuff. And the stakes are high, because if you miss one asset and don't get it right, those assets go through the court process. Okay, so it's an all or nothing type of deal. It's not like we can be off with regard to that. And then ongoing funding support. Hey, Bobby, we're buying a new property. We'll work with a title company and get a title property. We're opening up a new investment account. We're working with a financial advisor to get it all done right? So that's the way, the idea. Family meeting. In year one, no additional charge as long as it's done within 6 months of a signing meeting. I'll go over the plan as high level or as detailed as you want with whoever you want, okay? Just so that they know who we are, what to do, and key information. Every year, as part of that annual maintenance, we do an annual group client meeting, okay? And so I've been doing this through Zoom since the pandemic. I used to do them at these different conference centers, and in our office, we have a learning center. We may go hybrid, in the next year or so, but the Zoom ones seem to be doing good, where I'll go over in January and February all of what the laws have done, the laws that will impact the planning, what they've done over there, explain it to you, go over what's going on with the law firm. We update your reports, get them to you, and lay out our calendar for the year. Okay, and so that's our annual client meeting. And then every 3 years, we do group client update programs with the actual legal documents, okay? So on the clock, every 3 years, we're switching out the old trusts and old documents, putting new ones in according to the latest laws and your situation. And the tool that we use for that is we call it an estate planning review worksheet. Some of my clients call it the Cliff Notes of their plan. And so it's like a 17-page, it's actually less. There's some things at the end that talk about the attendance at the different programs. But hey, I want to change my trustee. Boom, just check it off. It's an easy way for you to make changes to your plan, your beneficiaries, your healthcare agents. Very simple, and we explain how all this works for you on that. Your personal effects, your wills, your guardians, if you have minor children, powers of attorney, and the like. So those are the two reports, right? Money, your instructions, puts us miles ahead right there. We just keep those things updated. Group educational programs. And so these are the programs not only for you, but your family members, your helpers, right? And so I'll show you what we have. I'll bring my calendar, what some of our events are here. So this is our website. We have a client dashboard here. And so the idea with regard to that is our clients, every year, the Saturday before Thanksgiving, we do a program. I used to call it Nuts and Bolts 1. What to do when a loved one becomes disabled, what to do when a loved one passes away. Our clients just say, make it required training and 911 info for beneficiaries and helpers. All right. So I do that program live. and then I put the recording up on our website. And so those are things that I don't care where you get the education, as long as you get it. I don't want you to be coming out of left field saying, what happened? Mom passed away or dad passed away, have no clue what to do. Those lay out the steps on that type of things. And different educational programs, like also because of the Secure Act is one on IRAs. I'm going to develop one once they come up with the proposed regulations. Once they make those proposed regulations final, a lot of my clients have IRAs. Okay, this is what they said, right? This is what they did. This is what you need to know. I'll probably do it live, and then I'll put it up on the website so you can hear if you didn't make it. DocuBank membership. So these are things on the initial setup that costs us extra money. We have vendors that we use, okay? And DocuBank is a service that we use. Is basically you have online medical directives. And what does that mean? And so the online medical directives, you're probably not carrying your medical directives in your back pocket if you get into an accident. But we'll give you a credit card, or DocuBank gives you a credit card. And the credit card, I'll show you, looks like this. And with that credit card, you can pull your directives, or your helpers can pull your directives, or the hospital person at the front desk can pull them in literally 15 to 20 seconds, okay? There's a member number and a PIN number on the card, and you just log in. The card also, it looks like this. Card also has an 800 number. If they, it's amazing how the hospitals or some of the healthcare providers won't even go onto the site and pull them down for you. So, okay, get your helper to dial this number 365 days a year, 24 hours a day, and it'll email or fax it directly to them, okay? And then I can just say, okay, print my documents, right? Just go ahead and print my documents. Boom, there's my documents. And now I have my medical directives right there on my computer. Hopefully it'll be downloaded. Boom. Okay. And so there's my medical directive. There you go. And so, but not even better. See, there's something about medication lists. So this is something my dad, it could have been great for my dad, is he had a couple of different medications. These are optional things. You can say, oh, dad or mom are on different types of medicine. We have it all in one place, the dosages when they take them. So you're not trying to figure out all that stuff. And a medical snapshot, if you wanted to have the doctors, the medical conditions, the histories, that is always helpful to have those things. Okay. And so that is also part of the maintenance plan and the initial enrollment. Okay. It costs us money to get it set up. And that's all I'm doing is passing the expense on. And now we live in a world where we have digital assets. Okay. If you have emails, if you have an Amazon account, if you have photos, if you have a website, all of that stuff are your digital assets. That asset review report is dealing with your financial assets, your physical assets, your real estate. What about all your online accounts? You probably have like over 100 passwords, usernames and passwords like I do. I don't want your usernames and passwords, and neither does the digital executor service. But we enroll you in that. And what happens on the digital executor service, for each of your different sites that you have, you're just telling them what you want to have happen to those accounts. Transfer that off to my beneficiary. Delete that account, delete that email account, transfer the photos over there, okay? And so the idea is for all your online accounts and issues, there is for all your online accounts, there is a plan for all of that. I had a question on the fee. So enrollment in our maintenance plan is $1,500 in the maintenance plan. And this is what we're doing. I'm going through that. And then after the initial enrollment, it's $975 a year. Okay. So that is for the maintenance. There is a setup fee for the plan, which I haven't got to. There's maintenance and there's after death. I'm breaking down the maintenance right now for you. So I'll make sure we're clear on all of that. So these are the things that are maintenance. Okay. And these are the little things that people miss often with regard to that. There you go. And so that is the deal for that one. All right. What else did I miss on that? I think I got everything on the maintenance there. Okay, so that's the maintenance plan. Try to pay it out for you. Optional. Okay, so it's not something you have to do. My clients, we have 300 families in our maintenance plan. We have a team of 12. Okay, we do a lot of things through processes and systems that we have. And we're good with regard to that. Okay. And we have about a 90, I think only 1 or 2 families dropped off, and it was very unique situation. So our renewal rate's like off the charts, like 98%. But you don't have to stay on it if you don't feel like you're getting value. My goal is to provide a A lot of value, right? I want you to, it's actually not even a moneymaker for us. It's just to keep our overhead, keep us maintaining the relationship so that we have all these things updated, right? Asset review report, estate planning review worksheet, the annual meetings, the client update, the family education and training. These are the things, that's our mission. We want the plan to work. That's where we're all driving at. So set up, maintenance, and after death. Okay, so secure appropriate systems for you and your family to transfer your wisdom along with the rest of your wealth. So we've set the plan up, we've maintained it. Now what happens at death, right? What's involved with that? So let's talk about some fees. We'll talk about after death fees first, because no one really thinks about that. So how do you control costs in the estate planning world? Number one is full funding, right? So here's that word again, full funding. So funding is putting all of your assets in the trust that are supposed to go there, okay? So that when something happens, you can just pass that box off to the next person. There's still work to be done, I'll show you, but we're not on the court schedule. Remember, one asset not in there, we're blown, okay? We have to have everything all set. So number one, that'll control costs. If I don't have to go to court, that should translate to cost savings for the clients. Proactive trustee and beneficiary training, right? So if your helpers went to those training events or understand what to do and understand our process and don't move things around, because we've done this 52 times already, okay? That we have a process that works and follow it, okay? And so as long as they understand that, then we're good, okay? It makes our job easier, makes life easier for everyone. We have a proactive engagement approach that say, hey, if you're on our maintenance plan, we'll agree to do the administration at predetermined rates, okay? Below market rates, which I'll show you. Your family does not have to hire us. Everyone does, but you don't have to. You're not locked in. I can't ethically bind your family to use us. Some of our clients want me to do it, but I can't. They have to say they're going to hire. Successor trustees have to hire us and sign that engagement letter, okay? So let's talk about the funding. I explained that. That's putting everything into your trust. I didn't put that little thing there. So now full disclosure of the cost. So here's the costs. We're going to talk about fees. So cost of the initial counseling and documents, cost of updating, cost after death. All right. So here we go. All right. So everyone talks about our focus on the upfront fees. I'm going to start with the back end fees because no one looks at the back end fees. I'm throwing Fairfax County schedules up here. They're the same as Loudoun. They're the same. I have Maryland on here as well. It's just a Maryland if there's any Maryland clients, but this is pretty much all of the Virginia has the same schedule. So this is if you decided to use a will, okay? And will, remember, goes through the probate process. And this is the fiduciary compensation schedule for executors and administrators. And typically what happens is someone will nominate a family member as an executor. They have no idea what to do. They hire an attorney and the attorneys will charge these rates, okay? Now, all attorneys won't charge these rates. Some will charge more, some will charge less. It just depends on your situation. But this gives you the statutory guidelines that are out there. So you know the idea of the market rate and how these fees, where these fees are at, okay? So will probate, okay? Virginia happens to be a reasonable compensation state. I love how they put that in quotes. What does that mean? So while the assets are tied up in probate, if there's any income being generated, dividends, interest income, and the like, 5% of those income receipts are a reasonable fee for the attorney or the executor. The next is your principal. So let's say you have $1 million going through probate. Well, the first 400,000, they can charge 5% on that. That's 20,000. They can charge 4% on the next 300,000, and the next 300,000, 3%. Okay. And so in the fine print in the back, it says the commissioner may increase or decrease the allowable compensation in exceptional circumstances. So it's typically that. Factors to be considered are determining, including the nature of the assets. Is it a business that we're having to deal with? Oh, that's going to go up. Okay. The character of the work, the difficulties encountered. So that's the issue. Okay. So that's if you have a will. Loudoun County is the same as Fairfax. It's just Fairfax is a fancier sheet. Montgomery County, Maryland, for you in Maryland, they make it pretty straightforward. They just say anything up to 20,000, they can charge 9%. Anything over 20,000 going through probate is 3.6%. Okay. That's what that means. That could be paid to the attorney. Okay. The attorney submits it to the court approves it. There you go. Florida statutes. Why do I have Florida statutes in here? Because I was just showing you wills before. Now let's talk about trust, because there's a lot of misconceptions about trust. Okay. And it's common. People just don't realize what's involved because you're not probably doing this a lot. So let's say you said, I like this trust approach. This is good. I don't want to go through the court process, right? So the Florida statutes are here to give you two teaching lessons. I don't know if anybody has Florida property here. That's not the point of this. The point of it is Florida has one of the strongest senior lobbies that are out there. A lot of people retire to Florida. Some people call it God's waiting room, right? One of my clients said God's antechamber. But the idea is they have a lot of seniors there, and they one of the few states that put a law on what an attorney can charge to do a trust administration. So the first teaching point is this, is that whether you do a will or a trust, when someone dies, it's a major life event. Okay. All of the issues have to be closed. You need closure on all of it. Every financial account, every piece of real estate, every tax, every debt, every credit card, every bill has to be wound up. Just because virtue that we have it in a trust, poof, everything magically goes away. Doesn't happen. Okay. It's people that do the work. Okay. And so you just need to understand you're just not on the court schedule, which should reduce the costs. That's number one. Okay. So, and even think about your online accounts, right? Think about that. And so something has to be done with all that stuff, right? And that's what administration is about, putting closure to all that. So there's work to be done, okay? Number 2 point of this is number 3, paragraph 3. I'll boil it down for you. And basically, I'm not going to read the whole paragraph. But basically, it says in Florida, which is a very good, strong consumer protection state for seniors, it says an attorney can charge 75% of what they could have charged on a normal probate, okay? And so they get a 25% discount in Florida for doing a trust and doing a trust administration. Well, let me show you Florida's rates, just because Florida's a consumer protection. So Florida looks like Virginia, but they're lower. And Maryland, they're lower. So Florida's probate rates are, if you're between a $100,000 and $900,000 estate, 3% is a reasonable fee. So if you're doing a trust administration, it's 25% off of that. And 2.5. So probably giving you more than you'd ever want to know, but you need to have context on how we set our fees. So here's how we set our fees. Our fees will start with the administration. If you're on our maintenance plan at death, okay, and your family hires us, we will cap the administration at 1.25% on the size of your net estate. And that's only due if we get hired, and it's due at that point in time where we say, yep, this looks good to us. You just saw 5%, 4%, 3%, 2%. We're well below that, and it's because of the maintenance plan. All right. The maintenance plan, if I have fully funded trust, I'm not going through probate, makes my job easier. If I have an educated family, makes my job easier, translates into a cost savings. If I have updated legal documents, right? I know where everything is at, makes my job easier. If I have a good planning partner who knows what to do, our back offices are in sync, great. All right. And so that's the maintenance plan. Okay. The upfront cost of setting up the plan, doing your counseling, titling everything into the trust and getting everything all organized and ready to go. We charge 0.5% on the size of your net estate, subject to a minimum fee of $4,000 and a maximum fee of $13,500. Where you land on that, I don't know. It depends on your goals, your assets, where you're at. If you don't like that option, option 2 is 1/3 of 1% on the size of your net estate, subject to a minimum, still of $4,000 is our minimum. Our maximum fee on that is $12,500. I have to make sure and confirm that, $12,000 and $12,500. And then the difference between the two is we're going to charge more on the back end if we're hired. Okay, we're going to charge 2%, just a flat 2%. We're not going to cap it at 1.25%. I don't care which one you choose, okay, that you understand why we're choosing these fees. I'm not giving you a document here only, okay? It's the counseling and it's all of the things, right? It's everything that you need for a non-taxable estate. Now, if you have more than 10 million bucks net worth, we're going to talk, right? We're going to have some advanced planning issues, and that's a good problem to have. But this is going to cover you for your trusts, your powers of attorneys, your medical directors, and actually coordinating all the assets, getting it all integrated and doing that, okay? It's not, here's your document, I'm going to the next person. So when we're talking and interviewing attorneys, ask them what their fee includes. Is it just the document or is it the real work that's involved behind that, okay? The $975 fee, will it go up? It goes up probably every 5 or 6 years. And the last fee increase was $50. Okay, so it goes up between $50 and $75 to keep up with inflation and our costs that are there. It's not going up $500, $200. It's going up those incremental amounts, and it's on that type of basis. What's in it for me is on the backside. I'm not what's called a will mill. I'm not doing a volume business. Okay, I'm looking for 60 clients this year. Custom plannings, more personalized planning, the follow-up work, the detail works. And then the maintenance plan is just an easy way to reduce stress for our team, because we know we have residuals coming in that can pay for their positions so that we can manage and handle the administrations. And we're getting more client referrals, which means we're doing something right from our maintenance plan. So that helps me. And then the settlement is a great way for me to, it has helped my succession plan, right? Because I would not be a great attorney. I'd not be a good attorney if I didn't have a good succession plan in place for myself. And so I have an external succession plan. One of the bios in the packet has Ed Clay. He is my backup attorney. He teaches with me at the National Network of Estate Planning Attorneys. He's agreed to take over my clients if I get hit by the bus, and I've agreed to take over his, until my internal succession plan is set up with my internal team. I think we're about 4 or 5 years away where I have a solid internal succession plan with my associate attorneys that are in the firm. Okay. So that's my succession plan. That's how we make money. It's very transparent. And so it's not like there's more cash flow. It's just better, more preparation, more detailed work. I'm not going after as many clients as everyone else is. Okay. You have to understand how those fees are set with regard to that. So the investment is up front, but after that, the heavy lifting is done, and we're just tinkering with that after that point. So I'm a Paul Harvey fan. I'm dating myself. He was a radio news announcer, and he would always say, "What's the rest of the story?" So I would ask the estate planning attorney, "Well, what's the rest of the fees? Here's what you're going to charge me for the document. How much are you going to charge me for trust settlement administration?" Right? And if they say, "I can't tell you that," say, "Here's all my assets. I die tomorrow. What are you going to charge me?" Right? You're probably not going to like what they have to say on that. And then if I become disabled, what are you going to charge me? Or on death? And that's the thing I was talking about. Is death tax return preparation included? In ours, it is. Okay. Probate services. This is a trick question. Ask them how many of their trust clients wind up having to be probated. Right? That should be a red flag. If they are doing trusts for their clients and they're going through a lot of probates for those trusts, that's a red flag. So we haven't had to go, we had to go on through one, and that was one where they had a foreign asset that's out there that we told them to manage, and they didn't get it. Okay, so it ruined my perfect probate record. But the idea is we're not going through a lot of probates, and that's why, because we're really vigilant on the maintenance plan. So our fees overall, if you look at the traditional probate, right, those are those fee schedules, 2 to 5% is just those administration schedules. Standard living trust planning, those are those Florida schedules. Ours is 1 to 2% for the life of the plan, and it actually works. And so that's our approach to it. So control costs, hopefully full disclosure of the cost, so you know what's in front of you. That hopefully will give you peace of mind. The differences between the traditional planning and the modern approach. Traditional planning, you have basic documents and questions answered. The modern approach is so much more, right? We've got the counseling, the funding, the maintenance, updating, the education, disability, right? Surviving spouse, helping the surviving spouse during their times, and then the settlement, okay? The next steps for us, our process chart looks like this. I find process produces predictable results. And so our process chart is here. Right now, everyone has attended this meeting. This is the Truth About Estate Planning experience. I can't get it to go up all the way. So that's about an hour with me, hour and 10 minutes with me, no charge. If you're interested in exploring further, you would do a discovery dialogue with either Wendy or one of our paralegals, and they're going to go, and there's no charge for that, where they're going to go through your personal information form, make sure we understand where everything is at, because I need to understand where things are at so I can give you recommendations and give you an idea what the planning is going to be, right? And then I have, there will be a goal setting exercise for you. What's most important to you? Disability planning is important to me, or remarriage protection, or creditor protection, right? So we go through, and so I know what's most important with you, and then we'll give you some homework on your helpers and the like. No charge for that one. The initial interview is kind of like the stop sign. That's where we go over specific fee quote, scope of engagement, exactly what we're going to do. Here's what we do. Is this a good fit? Are we a good fit with each other, right? If everyone says, yep, this looks good, because it has to be work for both of us, right? And so if that works, then we do the design meeting. The design meeting, usually 2 to 3 hours. I would never keep you in a room for more than 2 or 3 hours. However, we can break it up. I'm not charging you hourly, but that's that trip to the eye doctor. All the stuff that we do really depends on the thinking we do up front. Everything flows from that. So I really spend time to make sure we get everything right up here. And then there's a delivery and review meeting where we'll review the legal documents with you, make sure you understand them. If everything looks good, either we do those through Zoom or we do it in person. We can schedule a signing meeting to go through all the documents, make them formal, but we're not done, right? That's where most people, they might stop. If they get to that point, they stop there. The financial strategy meeting is where we're going to make sure your estate plan is coordinated with your financial plan and your assets, right? Okay. And then your financial advisor could be there, your CPA, whoever you want. And this is a strategy session where they're thinking, okay, you've got a business. Here's the best way to structure it. This is what you got. You got an S corp or buy, sell, whatever. Or you've got these IRAs, or you've got this insurance, or you've got this long-term care policy. Or so we look at it from the legal side, right? We're helping you on that, and planning and counseling with you, right? And so that's that meeting. And then the funding meeting, and we want to make sure we have an accurate inventory of all the assets, make recommendations on how to title things. And the funding meeting is where our funding coordinator, Ginny, is going to have all the magic forms to get everything in the right place. Okay. And then there's an optional family meeting. Oops, I got that wrong. I got a little double diamond there for some reason. Optional family meeting, no additional charge, with as long as it's done within 6 months of the signing, and then you're just on maintenance. So the heavy lifting is up front, right? And then we got it all set. You're good. Okay, just do it right, do it once up front, right? And then we just tinker with it. Then that's basically it. That's our process. Any questions with regard to the process? Any questions with regard to anything that I've had today, let me know. I'll stay on for a minute or so, and you can type in the chat as well, or you can, or just ask me the questions. That's fine. All right, very good. If you do have any questions, but the next step really is if you are interested, Michelle will just contact you and let us know. And if that's the and that's basically it. So Bobby Fazy, president of Insight Law. Hopefully this has been helpful for you. There is, if you look back at that sheet that I had given you, I think we hit all of those questions that I would be asking the estate planning attorney. Where did I find that? Those questions. Yes, someone asked if they will share a link. Michelle will be happily will share the link with you. So these are the questions. Hopefully I answered them all, right? Ask the attorney their background and experience in the estate planning. 70-30, I've been doing this since 2002. How do you define estate planning? That's our definition of estate planning. What's your counseling philosophy? That's that pyramid. Get to know you first, then present strategies. I just showed you our process chart. How will you counsel with me to design my plan? I use pictures and stories and visuals. That's the way I do it. How do we, this is an important one. How do we assure my assets are controlled by my instructions contained in my planning documents? That's the funding. That's the big part of it, right? Who's responsible, you or me? That's just find out. That's a big deal. How do we assure my plan stays current with changes in the law? That's our maintenance plan. What's the level of involvement of my family? I think more involvement's the better, but every family dynamic is different, so we deal with it. But communication and transparency makes, if they're ready for it, then it makes things go smoother, right? How do you charge for services? I showed you probably ad nauseum, more than you ever wanted to know, but I'm just very transparent about it. What's your record with regard to probate? Okay, I'm 52-1. So there you go. And then do you handle the filing of the death tax returns if they're necessary? Yes, we do. What happens if something happens to you? That's my succession plan. How do I prepare for our consultation? Just complete your personal information form so that we know what your situation is, financial at least. What type of service should I expect from you? I'm a big believer in the team. Okay. And so everyone's got a role. You're better off with everyone on the team working for you. I mean, everyone got different people. Do you expect any commitments from me? Just basically, just respect our time, our process. Think about those goals that I went through, those different counseling issues. We'll do a goal exercise. Think about candidates who could be your backups for the financial and medical stuff. You don't have to come up with a final answer if you don't know now, but just think about candidates and then your assets. We need to look at how your assets, or if you have any advisors that could be involved. So with that being said, that I am done now. So thank you very much for your time. It's been Bobby Fazy, president of Insight Law. Hopefully we got some good education in on the estate planning side. So thanks a lot for attending. Appreciate it. And I'll get Michelle to share the link.